Hi, I'm Troy Pickard. I'm a landlord-tenant lawyer here in Oregon, and I'd like to tell you a little bit about Oregon's new law about rent increases for tenants. In Oregon, a landlord may not increase a tenant's rent during the first year of a tenancy. After the first year of a tenancy, a landlord may increase a tenant's rent with a 90-day notice. The amount of the increase is limited to 7% plus the CPI. The CPI is a government measure of inflation, and in 2019, the CPI that the state of Oregon is using is 3.3%. That means that in 2019, the maximum amount a landlord could raise a tenant's rent over a 12-month period would be 10.3%, 7 plus 3.3%. In the future years, CPI may change. The state of Oregon will publish an updated CPI figure on the Oregon.gov website at the Office of Economic Analysis. One important thing to keep in mind is that the maximum rent increase of 7% plus CPI does not apply to buildings that have been open for fewer than 15 years. I'd also like to talk to you about how Oregon's laws have changed when it comes to terminating tenancies. When a tenant has done something wrong, the rules on terminating tenancies have not changed, but they have changed when a tenant has done nothing wrong. The new general rule is that if a tenant has done nothing wrong, a landlord may only terminate that tenancy if they have one of four reasons. Number one, if the landlord intends to demolish a unit or convert it to a non-residential use. Number two, if the landlord plans to do renovations or remodeling to a unit to such an extent that it would be unsafe or unlawful to occupy during the renovations or remodeling. Number three, if the landlord intends to move an immediate family member into the unit and there is no comparable unit in the same building. And number four, if the landlord intends to sell the unit to a buyer who intends to occupy the unit as their primary residence. If a landlord elects to terminate a tenancy under one of those four options, the landlord must give the tenant notice 90 days in advance. And at the time the landlord issues that notice, they must also pay the tenant 1 month of rent. There is an exception to that 1 month of rent payment rule. The exception is that if a landlord owns no more than 4 dwelling units, they are not subject to the requirement to pay their tenant 1 month of rent. There are also some exceptions to the general requirement of those 4 landlord-based causes. The first exception is that if you're in the first year of a tenancy, a landlord has the right to terminate that tenancy with no cause by giving the tenant 30 days notice. There's also an exception for landlords who live on the same property as their tenants and when there are no more than 2 dwelling units on that property. In that scenario, a landlord retains the right to terminate with no cause with 30 days notice in the first year or with 60 days notice after the first year. This new law is complicated and there are a lot of exceptions. So before you make any decisions, you should talk to your own lawyer about your specific scenario. If you have questions about other legal topics, you can find answers on the Oregon State Bar's website. Thank you.